is Kara Hamley O'Donnell. Kara is a city planner and historic preservationist who worked for the city of Cleveland Heights for 25 years, and she is now principal planner for the city of Shaker Heights. With an undergraduate degree in architecture, she holds a master's degree in historic preservation planning from Cornell, where she wrote a paper about the theater we are in right now, followed by her master's thesis on the Euclid Heights allotment, which predates the creation of Coventry Village. Her thesis later helped the nomination of this area to the National Register of Historic Places. So, Kara, take it away.
Very strange to be in the spotlight like this. Okay, can you hear me? Okay, great. Okay, you can go to the next slide. So I understand that you just came from the Garfield Monument, and one of the things, the question is, what do the Garfield Monument and the son of Vice President John C. Calhoun have in common? And the answer starts in South Carolina with Patrick Calhoun, who was a railroad man in Cleveland, and was coming to Cleveland on business from South Carolina, and asked someone to take him to see the Garfield Monument. And it's the story goes that the best way to look at it was from a field on the farm of Worthy Streeter, which is right around where we stand now. So the idea was that he came here, approached from the monument and saw this piece of land and became intrigued. Next slide. So at the time, in these slides, there's a little star where we are, just to kind of orient you. And so where we are now was on the edge of what was becoming very crowded, very polluted. It's sort of the typical story of a very dense community, dense city, and people keep kind of moving out. And this was the farmland at the time. Dr. Worthy Streeter was a gentleman farmer, and he harvested the the lumber that had been here, and he also had a horse race track just for kicks. And so this area at the time was called the Heights. It was also referred to as Turkey Ridge because there were a lot of turkeys here. And many of you who know Cleveland Heights probably remember a bar up the street that used to be called the Turkey Ridge that was there for many moons on Coventry. Next slide. So he had substantial holdings, and when Calhoun saw this space, he really realized that this was the kind of place that could be developed into a suburb to attract Cleveland's very elite. Next slide. He did recognize that potential, and so in 1891 he purchased 240 acres from Worthy Streeter, and then the price at that time was over $1,000 an acre, which was unheard of in a very rural community in 1891. And then he acquired additional land to kind of create the whole space that he needed to do the development. At that time, then, he hired landscape architect Ernest W. Bowditch, who was a Bostonian, and asked him to help lay out the roads and the streets and the landscape for what would become Euclid Heights allotment. Next slide. So Calhoun was likely aware of Bowditch because of his involvement with the Cleveland Park Commission. If you drive down Martin Luther King Boulevard today, that land was donated by John D. Rockefeller, and so people who've been here a long time know that was called Rockefeller Parkway before it was called Martin Luther King Drive, and Bowditch was brought into town by Rockefeller and others to design the parkway that we see there today. So it makes sense that knowing that, and this in effect joins with that land, and so this was sort of seen as an extension of that development. Next slide. Oh, I will say, Bowditch, so this became my master's thesis in part because of Ernest Bowditch, and at the time he was seen as an outsider by the local landscape architects in Cleveland, and in his memoir he remembered that the locals who didn't want him here, they were trying to drive him out of town, and so he said that the way they did that is they put him on a boat in Lake Erie with reporters and loose women. That was what he accused people of to try to drive him out of town. Next slide. And so by 1892, the preliminary plans were in place. And for those who are familiar with this area, this is, I missed a slide. Hang on. Or did I skip one? Let's see. Well, there we go. There you go. That's where I'm at. So that's the preliminary plan. It has some similarities to the plan that actually got laid out, but it has some differences as well. But the idea was they were looking at that garden city kind of aesthetic that was very popular in suburban development in the late 1800s and through the teens and the 20s, of the curving streets with English-inspired names, and the idea of sort of feeling more rural. And so this is the first plan that was laid out in 1892. Next. So then he started marketing the development. And this predates the establishment of the city of Cleveland Heights. Actually, Cleveland Heights was established in 1901 as a hamlet. In 1903, the state changed the designation. There were no more hamlets. It became a village in 1903. It wasn't until 1921 that Cleveland Heights had the population to be considered a city. And so in 1892, this was just East Cleveland Township. And so he was really sort of the first game in town as far as developing this part of the east side of the Heights. And so he was advertising as this being the Cleveland's park allotment. And he went to the effort of installing all the utilities, planting trees, putting utilities and sewers in. And he knew that it was important to have that infrastructure if he was going to bring people here. Next slide. So this is a little zoom in. This sort of predates zoning. And so what happened was these developers, and we've all heard of the sort of discriminatory deed restrictions that could be put in place in earlier years. This did not have any race-based restrictions, but it did restrict setbacks. It restricted height, it restricted size, and it restricted the cost you had to pay. So it's not super legible at the scale, but on the right, it sort of said on certain streets, which are sort of the main drags, you had to spend at least $3,000 when you built your house, and $4,000 and $5,000 was the sort of minimum. At that time was quite grand. However, the sales were really slow, and it wasn't easy to get up here at that time. Next slide. So many of you probably drove up Cedar Hill on your way here. This is Cedar Hill in 1890. So you can imagine if you were a rich person who wanted to get up to a fancy house, this was probably not your ideal way to get there. Next slide. So Calhoun piggybacked on John D. Rockefeller's donation of that land, and he donated the area. This is sort of showing you Cedar Hill is sort of to the right, this sort of scratchy part going up. And to the left, the darker part is Rockefeller Parkway. And so he wanted to connect to that parkway as a way of drawing people up the hill, but he also wanted to use it. He donated it to the city, but he kind of said, but wait a second, I need an easement to drive a streetcar up there. So he donated the land, but it was a little bit self-serving. So, but that would allow people to get up to his development. And so he, again, added more infrastructure costs by installing the streetcar. Next slide. So this is the streetcar going up Cedar Glen. So this is sort of, down to the University Circle is to your left. Overlook is sort of in the middle there, and this is coming up the hill, sort of standing in the Chestnut Hills neighborhood. And it ran on the south side of Cedar Glen. There's a bike trail there now. It didn't run in the middle of the Cedar Glen. It ran on the south side where the bike trail is. And then it came up and it either turned onto Euclid Heights Boulevard, went up Coventry and out Mayfield, or it went straight out Cedar, and then later on also went Cedar and turned onto Fairmount Boulevard. So it ran in the middle of Euclid Heights Boulevard. And then in Cedar, once it got up the hill, it ran, in the middle of the street. So, one of the things I think is interesting is you start to look at the streetcar lines as some of the sort of these things that are reminiscent of where they were, like the medians where the streetcars ran. And in some cases, some of the posts that held that electric railway are still exist in places like Euclid Heights Boulevard and Fairmount Boulevard. Next slide. This is them building the streetcar in the middle of Cedar Road. On the left is the Heights Center building, which is where the Starbucks is. And so this is looking eastward. Next slide. So he was starting to bring the streetcar up the road, but this is it in 1898, and you can see again the star is where we are. Each one of those little dots represents a house. The rest of it represents field that should be houses. So he wasn't doing too well on the sales in 1898, despite the fact that he'd invested all that infrastructure in the streetcar. He decided that perhaps in order to draw people up here, maybe a golf club would work. Next slide. So he built a beautiful clubhouse called the Euclid Golf Club, and it was, again, one of those things to bring the elite in. Next slide is another slide. Mead and Hamilton, who were one of the premier landscape or architects of the time, designed the building. I love this because it shows you how old it is with all the horses in the foreground. Next slide. It was an 18-hole golf course. The upper 9, which were on the sort of right and bottom of the screen, were owned by Calhoun, but the ones on the left were owned by John D. Rockefeller, who was a very religious man. And so if you wanted to play golf on Sunday, you couldn't play on his course. You had to play the upper 9 twice. And that development was usually later developed into, he sold that land and it was later developed into the Euclid Golf Allotment, which is another high-end residential development. Next slide. By 1903, only 46 families lived there, and they did unite to form an improvement association because they needed to sort of secure modern conveniences like street cleaning and a night watchman, street lighting, and basic costs to do that because the city was not large enough. This was a rural community, and they needed to, kind of keep up with the custom to the life they were accustomed to. And so at that time, by 1907, the socialites had started to move here. And in the case of Calhoun, sometimes he built the houses and rented them to rich people just so he could say that so-and-so lived here and so-and-so lived here. They never owned the house, but of course he didn't advertise that. But he was using them to lure their friends up to the area. By 1907, there were about 75% of the people who lived here, which was only 69 families, were in the Blue Book. So he was being successful to some degree. Next slide. This is the first home that was built for architect Alfred Hoyt Granger, and he was an architect as well, so he designed this for himself, and it was the first house that was built here. This is on Overlook. Next slide. This is just a slide that sort of shows the postcard of that era. In fact, the house that's on the left there was, I'm blocking on the name of the house, but it had Tiffany stained glass, and if you go to the art museum, and there's an area where you'll see the stained glass from this building from when it was torn down, and this very postcard is, they used a copy of this postcard to show what the house looked like. Next slide. This was the William Rice house. He was instrumental in helping Calhoun secure the land that would be this allotment. He was an early investor and an agent, and later he was murdered, and that's a whole other story I don't have time to get into. And someone else was accused, and it was a whole soap opera. You can Google it. It's an interesting story. Next slide. This guy, John Harkness Brown, was actually accused of murdering him, and this was his house. Which I love this one because I love to see these in construction shots. This was built in 1896. It's a local city local landmark as well as within the National Register District. Next slide. Patrick Calhoun also built himself a summer home here, just a little summer home. This was unfortunately torn down. It's on the site of Cedar Hill Baptist Church, which is on Cedar Road. So next slide. So Patrick Calhoun was sort of trying to do a lot of things at once. Again, he wasn't from here. He was from South Carolina. His interest was mostly railroads. And so he moved his family in 1905 to San Francisco and was getting in with his railroad endeavors. And at the time, the city was trying to decide whether they wanted to do subways or trolleys in San Francisco. And he was advocating for trolleys. And they decided just before the 1906 earthquake to do trolleys. And so that kind of paused a little bit. At the same time, Calhoun was trying to ensure that they chose his trolley system to operate in the city. And in 1911, or in 1908, he was accused of bribing officials to do that. There was a long, protracted court case. And in 1911, it was dismissed because there was allegedly a conspiracy and a planted juror and all kinds of fun stuff. And he, dealing with that case, as well as trying to sell lots here, he spread himself too thin and was losing. He didn't have any money, and he was on the verge of bankruptcy. Next slide. So in 1914, you're starting to see more development, but there were still homes, in little clusters, but still a lot of empty land. Next slide. So in 1914 and 1915, hundreds of properties were posted on sheriff's sale to pay back the Cleveland Trust. There was also some documentation that he had taken loans out from John D. Rockefeller as well. And at the time that the sheriff's sale went up, all of those deed restrictions were lifted. So his idea and his picture of these giant homes on large lot for Cleveland's elite kind of shifted from that point. And so lots were sold separately, or big chunks of lots were sold together. And what that did is made it so that it opened the door for the Coventry Commercial District, it opened the door for apartments, two-family dwellings, and for the Cedar Fairmount District. This development goes all the way from Coventry all the way down to the Cedar Fairmount District. Next slide. So this is 1920, and that little star and that little black blob to the star is the theater in which we are standing, which was built in 1919. And again, you can see this was really the first building that was built in the Coventry Commercial District, which I think is so interesting that, you know, they'd be like, well, we'll just build a theater and hopefully the rest of the district will come after it. But you can see there's nothing up and down Coventry, which runs to above where the star is. But you can start to see things are filling in, you know, even from 1915 to 1920, we really got a lot of development in Cleveland Heights in this area at that time because the people were able to buy the lots more cheaply. Calhoun had spent all that money on infrastructure, so that was in place. So it made it much more marketable once he was sort of out of the picture. Next slide. So that was in 1920. So in 1921, Cleveland Heights established the state's first zoning code. They hired the same guy who wrote New York's first citywide code, which was the first citywide zoning code in the United States. And we hired the same guy 5 years later. And the code was written, as I said, in the first in the state. Next slide. And this sort of shows you this area. And what I think is interesting is that this is the zoning code today, but the zoning code of 1921 basically took what had happened from 18 whatever to 1921 and sort of said, okay, all the apartments are over here, we'll make that multifamily. All the two families are here, we'll make that two family. And so the code today, the map it's colorful now. It was black and white then, but the zoning code is really not that different from what it was in 1921 because they basically just codified what had happened on the ground. And it sort of tracks, so the lighter colors are the large single family dwellings, which were sort of where the land was built, or the properties were built. The dark brown is the apartment, and the purple are sort of commercial districts and apartment districts, so that still stands today. Next slide. So by 1928, this is, you know, following the new zoning code and following sort of what was happening, you can see that it's mostly developed, which is a good thing because in 1929, starting in 1929, people weren't building a whole heck of a lot of stuff. So for the most part, the area got pretty developed. And the little U-shaped dot at the bottom was Calhoun's very large house on that very large lot that unfortunately got torn down that I showed you the picture of. Next slide. So then I'm just going to go through some pictures. I mean, some of you are probably familiar with Cleveland Heights and some of you probably aren't. But what I think is so interesting about this is I think it's infinitely more interesting since the change in losing the zoning regulations. On the upper right is a carriage house that was built in those early days. It's been converted into a house. We've got apartment buildings in the upper left, lower left, and then a large house in the middle, and then two-family dwellings, which are sort of what's called the Cleveland double, which is pretty ubiquitous in greater Cleveland, and that's why it's called the Cleveland double. Next slide. These are some of my favorite apartments. These are on Hampshire Road and Euclid Heights Boulevard, and I just love the big porches and the big windows and the details that went into those at that time. They weren't doing them cheap. Next slide. And we had more commercial buildings. We had, Tudor Revival. We have this theater here. We had the Alcazar Hotel, which was built in 1923 at the Cedar Fairmount area. Next slide. And then we had Coventry Village, which wasn't really called Coventry Village, but I think that was probably something Bruce may know better, but I think probably in the 60s and 70s is when that sort of name came about. Next slide. This is from Euclid Heights Boulevard. So the theater is just off to our left. This is looking north on Coventry. This little cute gas station in the right is now the Huntington Bank, unfortunately, because I love that little gas station. But you can see a group of kids getting ready to cross the street from the school, which is sort of off off slide. Next slide. Here's a quick little history. So this is the theater, and so it was, as I said, it was the first commercial structure. It was designed by architect Alfred Janowitz, and you can see the train tracks in the foreground. This was a 1,300-seat theater, and as Bruce mentioned, it was sort of this. We're in the balcony, and the downstairs was the downstairs, so it was a big theater, and it was actually built as a silent movie house. And you can see here on the left that they were saying that the little Irish organist was Frank Gallagher, and he will give a special program Saturday afternoon. So this was originally, in some of the early plans, you can see where the organ was in the theater. And then in 1929, they did an addition on the back so that they could have sound here. Next slide. Again, I think these are interesting. You can see the streetcar lines in the foreground and the streetcar. One of the things as you walked in here, you probably saw that little area where everybody kind of hangs out. And it's called Coventry Yard with the big concrete things to sit on. The reason that's there is the streetcar had to take a turn. The reason these buildings are kind of curved is because the streetcar couldn't go up to Coventry and take a hard left. It went through that area where that Coventry Yard is. Next slide. This is sort of maybe a precursor to the next speaker, but there was a raid in 1922 because they dared to show a movie on a Sunday, and so they were the theater's two owners and the projectionists were found guilty of breaking the law prohibiting theatrical performances and other forms of entertainment on the Sabbath. That was 1922. And then in the next slide, in the 1940s and 50s, Coventry, the commercial district, sort of catered to the immigrant Jewish population. In the 60s, it sort of became a haven for hippies, Hells Angels, radicals, poetry readings, and artists. Punks later dominated the streets in the 80s and the 90s. And today, the area continues to, I think, sort of attract people who are kind of the counterculture. In 1992, Damian Porter, who was a resident, described the district as, quote, an identity crisis in transit through time. Next slide. As far as the theater, I'll leave the colorful history of the theater in the 60s and the 70s to the next speaker, but we alluded to the fact that this, and Bruce mentioned, this was a theater, an art house theater in those times. So there was that sort of decade or two of that part of its history. And then in 1990, the theater was renovated. And originally they created two theaters. We're in one of them. And then downstairs was was the larger theater, which was later a bar and then a church. So you have that sort of eclectic Coventry vibe that sort of has followed us through the time. So with that, I'm going to...
It goes to me first.
Oh, it goes to Bruce. That's right. Sorry, Bruce.
If you could change slides. Next slide. It should come right up, right, Kara?
I sent it to him.
You sent it to him?
Nope.
Oh.
I emailed it to you. Did you get it?
I'm not sure if I did. I'm sorry.
I emailed it to him separately.
If somebody could grab this, I've got it on a thumb drive. It should be on the first one.
Sorry, Bruce.
That's okay. Okay. I just have a short 5-minute presentation that leads into the discussion of the Coventry Village Special Improvement District. If you pull that up, it should be marked pretty clearly, Coventry CLE or something like that. All right, while he's pulling that up, I first set foot in Coventry Village in 1968. I grew up in Akron and Canton, but you had better hippies up here. So we used to hitchhike up here, and you had Irv's Deli was here at the time, and Bill Jones' Leather Shop and Coventry Books, Daffy Dan's T-shirts, and the Hells Angels hung out at the Seesaw Cafe. For those of you who remember that, and a little while later, I think it was 1970, 72 maybe, Tommy's opened up, serving food the likes of which we had never seen before. What is a falafel? What is a baba ganoush? We didn't know what those things were, but he opened back then, and the area was surrounded by hundreds of apartment units offering cheap living with those long railroad-style apartments that could hold far more occupants than what the code probably allowed back then. How are we doing? Did you find? Okay. And then I signed my first lease on a Lancashire Road apartment in 1973. I got active in the politics of the community, eventually becoming chairman of Coventry Neighbors and running the Coventry Street Fair for a couple of years. The big old street fair, you know, that had like 60, 80,000 people over a period of 3 days. The Coventry that I first saw in '68 was in transition. You can go to the next slide, and you can see what I was just talking about here, Coventry Books and Carol Drug, and the next slide, if you would. All right, and you know, the Heights Art Theater was showing the Rocky Horror Picture Show, and who's that guy on the left there with a beard? I don't know, pay no attention to him. But I happened to come across that from the old street fair. Anyhow, it was a neighborhood in transition, and in the early 1980s, it was kind of getting kind of scruffy, and the merchants were having a tough time because like any other merchant association, it was voluntary. So you would have half the merchants who belonged to the Merchant Association doing all the promotion for the entire neighborhood with, you know, with limited dollars. When it came time to picking up the trash, to street cleaning, to snow plowing, you only had, again, half, maybe sometimes even less than half the merchants paying into that fund. And the property owners at that time were really not much help. You can go ahead and switch. All right, so as I mentioned, we had a neighborhood organization called Coventry Neighbors. That was a traditional 501c3. And we took a great deal of interest in the commercial area because it was the stores we liked and our friends all worked there. And then, as I mentioned, they had their own merchant association that was separate from us. We did our best to support them. And some years later, we helped them put together a business association, a 501c4, so they could at least start to attract some grant dollars and kind of spiff the neighborhood up. But even then, we didn't have enough money to hire anybody. It just wasn't enough money. Well, we heard about something called a Special Improvement District, or a Business Improvement District, actually, in New York City. Times Square had the first Business Improvement District, and that is where the property owners, not the merchants, where the property owners got together and to tax themselves. And sometime around 1995, the Ohio State Legislature created the ability to create special improvement districts in the state of Ohio. The first one was in Dayton, Ohio. That covered some portion of downtown Dayton, and as soon as that was created, I contacted the city of Cleveland Heights, and my firm was hired to put that SID together, you know, here in Coventry Village. Now, I didn't know anything about putting SIDs together. It wasn't what we did, but I knew all the merchants and I knew all the property owners, so the city said, why the heck not? A special, you can go to the next slide, please. A special improvement tax district is a delineated geographic area where the property owner, not the store owners, elect to pay an additional assessment in order to fund public improvements that benefit the district. And you can see a list of allowable expenditures on this slide, but it's important to note that the services offered by a SID cannot replace city services. A good example would be security. If you have a SID in place, the city can't say, well, we're not putting police there any longer, but a SID can hire off-duty police, can hire private duty police to add on to what the city is already doing. My original plan in 1996 was to create a SID that encompassed not only the commercial stores and properties that right along Coventry Road, but I wanted to take it all the way down into the apartment districts, because obviously the more properties, the more dollars we could bring in. And at that time, the owners of the apartment buildings said, go away. Are you kidding me, Bruce? We don't have anything to do with you. We're 99% leased. Right? We don't need you to keep the neighborhood up. We're fat and sassy and we're happy. And I don't know that I was prescient in any way, shape, or form, but this was before Hingetown, this was before West 25th, this was before downtown's resurgence, you know, and all the other neighborhoods, Tremont. I just said to them, guys, you're going to be sorry someday. I mean, you will not always be where you are today. And sure enough, I must have been prescient in some way, because you don't have the occupancy, you don't have nearly the high percentage of occupancy in this area that you used to have. Because now, if you're young or in your 30s and you want to have a hip urban experience, before you had to come to Coventry. There was nowhere else in Cuyahoga County you could go. Now you've got all sorts of other choices. So that's why the SID actually got drawn as narrowly as it did. let's see, the way the SID is once a SID is created, a budget for revenues and income is established, and then it all goes to the local municipality, in this case, City of Cleveland Heights, to City Council for approval. Once it is approved, the revenue comes from an assessment on the real estate, which is collected by the county and ultimately passed through to the SID. The SID is governed in this manner. Every property owner is a member. Did I go to, let's see, go to the next one. Yeah. The SID is created by a petition that I circulated trying to convince the property owners to sign on. And as soon as I was able to get 60% of the front footage, which was easier to get than 75% of the square footage, the SID came into being, and it forced all the other property owners into this district. And as I said, we created a budget. We went to City Council, got the City Council to approve it, and then it became a tax, a property tax that went against the property owners. Let's see, the way the SID is governed, every property owner is a member. And the members, next slide, please. The members elect, I think it's the next slide. The members elect a board of directors from amongst themselves with the addition of one person from the municipality, perhaps a council person or someone from the planning staff. And on the current slide, you can see that board members are considered public officials. Yeah, board members are considered public officials, but they are not considered as holding a public office and are therefore not required to file a statement with the Ohio Ethics Commission. Other local SIDs that you might be familiar with are the Downtown Cleveland Alliance and SIDs in the Cedar Lee and Cedar Fairmont commercial districts. Like I said, it's always nice to have a merchant association for camaraderie and kind of a local identity. But the way to go is to create these SIDs, and now there are probably, I would venture to guess, maybe 100 of them around the state of Ohio. And I believe they just created a special SID that goes from way out east along Lake Erie and then comes all the way along west, and they are putting that together to raise dollars for public improvements and the whatnot. So that is my short presentation on how this area, this special district got put together. And now, Carrie, are you here? Carrie, you're going to introduce Professor Geronimo. Okay.
Thank you.
Thank you.
All right, we've been moving around a lot today. So I don't see, oh, there he is. I was out greeting people. Our last speaker of the day is Andrew Geronimo. He is, what's your current title right now? Director of the First Amendment Clinic at Case Western Reserve University. And I know Andy from our days at the Bar Association, law clerking as bar counsel. So Andy, thanks so much for being here. And I will leave this here for you. Was there a stand? No? Oh, okay.
Thanks.
Yep.
Hi, everyone. Thanks for coming. All right. As Carrie said, I'm Andy Geronimo. I'm the director of the First Amendment Clinic at Case Western Reserve University School of Law. My colleague and I work with third-year law students in their last year of law school and give them sort of their first experience to practice primarily in cases dealing with free speech and the First Amendment. I do have a connection to Coventry Village. I used to live over here on Hampshire during law school, and actually my very first job was on Coventry. I was a dishwasher at BD's Mongolian Barbecue in the late 90s. So happy to return to Coventry to be talking about this very important case. So we'll be talking about Mr. Nico Jacob Ellis. And if you could go to the next slide. This is Nico Jacob Ellis. He was an Italian immigrant, and he was the manager of the Heights Art Theater. I was pleased before we got started here that a member of our audience said that he was here during the time when Mr. Jacob Ellis exhibited a movie called Les Amants. And I'm not a French speaker, so you'll have to bear with me on the pronunciation of that. But Mr. Jacob Ellis screened a version of this film in this theater and was arrested by Cleveland Heights police and charged with 2 counts of exhibiting and let's see exactly what it is, possessing and exhibiting an obscene film. So if you go to the next slide, this is the poster for the film. Les Amants is, I have not watched the whole film, I'll tell you that, but I will tell you from the online descriptions, it's a film about a woman who has an affair with somebody during her travels. It won a number of prizes internationally. It won a prize at the Cannes Film Festival, and it eventually spawned this case. I think primarily this film is most well known for spawning the Jacob Ellis versus Ohio case in the United States Supreme Court, which is sort of a midpoint along the court's jurisprudence of what it means to be obscene. It's a well-known case, but it's not existing law. There's a subsequent case called Miller versus California that maintains the proper standard for obscenity, but it shows, the case is important for a number of reasons. One, it's important because it was an early rejection of the idea that exposure to minors, so exposing this film to minors, could be adequate reason to regulate it as obscene, as being outside of the protections of the First Amendment. It's also important because there is some discussion about the artistic nature of it, right? So as the Supreme Court develops this test, part of what it's concerned about is what is the redeeming social value, as the court puts it in some of these cases, of showing a film like this that people object to. And it really shows the justices struggling to apply an obscenity standard in a way that provides a clear rule going forward, so that people like Nico Jacob Ellis, in possession of a film like this, could know that it either was or was not covered by the criminal statute for obscenity. And actually, this film was displayed, exhibited in a number of different localities. It was submitted to multiple censorship boards, motion picture censorship boards, and certain of these boards clipped certain portions of it. I think that there were 3 total cases where law enforcement or prosecuting attorneys took issue with it, but the most famous of which was here in Cleveland Heights. So if you go to the next slide, I pulled it up on Rotten Tomatoes. It has a 90% on the tomato meter. But I was just Googling it, trying to figure out the plot of this film, because I was not prepared to watch it in its entirety. But it's funny to me that on the Rotten Tomatoes website, which if you're not familiar is sort of like an online review of movies, they have the old Cleveland Plain Dealer film critic, W. Ward Marsh, who says, "Without its shockingly nasty climax, the lovers would be shunned by all moviegoers. With it, the prurient-minded will have a ball." I believe this was even used in that litigation when a panel of 3 judges here in Cuyahoga County found that the film was obscene. Part of what they used to substantiate that finding was some of the testimony like this, that it appeals only to the prurient interest, and we'll get into the word prurient, which is always a struggle for law students in con law to pronounce. So if you go to the next slide, I have here a bit of some of the, this is an excerpt from the oral argument in the Supreme Court. Mr. London is representing Mr. Jacob Ellis, and this is actually the first argument of the case. It was argued twice. But I'd like to play this just to isolate the idea that the clip that I will show you after this is really the clip that motivated the enforcement action. So go ahead and play that first clip.
As I say, I shan't describe the film itself, except to mention that particular objection seems to be taken by the state and by the Ohio Supreme Court to one sequence in the film, which, as a matter of fact, is not within the range of the camera.
And the next one as well, please.
What is on screen is a woman, Your Honor, and you see her face and bare shoulders. She is lying in bed, and prior to that time there has been a scene of lovemaking between the woman and the man. You don't see any act of love, but it's quite obvious that they are making love to each other, or at least that they're in the bed for that purpose.
Okay, I hope I'm never in the position where I need to articulate to the United States Supreme Court what a sex scene depicts, but there we have it. Having given you this knowledge of what Mr. Jacob Ellis's lawyer said about this scene in the film, I do want to warn you that I'm prepared to show it. So if any of you are queasy about acts of love that are implied but not explicitly shown, now would be the time to take your leave. But I'm going to ask to show this.
Oh, Mama.
Oh dear. Oh dear. That's incredible. And also with the recent Supreme Court actions, I'm like looking at the exits to make sure that the Supreme Court would still uphold that this is not an obscene film. Yeah, so not to. This was the 1959 was when the initial prosecution was brought. But you said you were here in 58. So he showed it in 58, but I think the initial case was brought in 59. And it's sort of like within the context, right? So this is a foreign film, it's a French film, and this is the time, it's my understanding of like when Ben-Hur was the big hit in theater. So rather than showing the big blockbuster of Ben-Hur, Nico Jacob Ellis here at the Heights Arts Theater was showing Leamon and sort of these artistic films. And I think part of the objection to this from some of the censors was just not just the I stop myself before I say the explicit nature of it, not only what it implied, but also the idea of the plot elements, right? So that this was a woman who was being unfaithful to her husband, I think played a key role in some of the censorship bits of it. But you can see the court in the oral argument really struggle with how to apply this obscenity, which in previous cases, and I'll address it briefly, had said that things that are lewd and obscene are outside of the protection of the First Amendment. So you don't have to do any hardcore First Amendment analysis on things that are seen as obscene because they're outside the scope of that protection. But the court is really struggling with how to apply this to something that is really art, right? So it's not just something that is isolated, and you see that in some of the argument that took place in the case. So if you'll go to the next slide and play the audio there, here will be some explanation, some in between, some back and forth between Justice Stewart and John T. Corrigan, who was the prosecutor defending the conviction.
This movie has won some prizes based on its artistic merit. Do you think those prizes were awarded purely on this 3-minute objectionable sequence?
I cannot pass judgment as to why the prizes were awarded, what standards were used. I have no knowledge of that, Your Honor.
But it's your view that without this 3 minutes, which you say is criminal, that the movie would be entirely without value of any kind?
For any purpose.
Artistic or otherwise.
The 3 minutes is dependent upon that which comes before, and that which comes before certainly is dependent upon the climax that is reached in the last portion of the movie. 3-4 minutes, I don't know specifically time-wise, just how much time there is.
So what Mr. Corrigan is doing here is he's trying to isolate the part of the movie that shows the sexual content and is trying to show that the whole movie was leading up to there. And that was an important point for Mr. Corrigan to make here because as the tests had developed for obscenity, you had to show that that a piece to be obscene was without, quote unquote, redeeming social value based on a case named Roth versus United States that was a little bit before this. So what Mr. Corrigan is trying to do is trying to strip all of that out and say the entire movie was directed towards this scene. And actually, Mr. Corrigan in this argument, I think, was trying to offend the justices a little bit, right, with these words like referencing the climax and referencing specific sexual acts that he assumed were happening off screen. And he had to do that because the prior tests had required that the content be totally without social redeeming value in order to be found obscene. Ultimately, if you go to the next slide, the court found that this case, that the film was not obscene. So in order to sustain these convictions, the key issue in the court was whether or not this film was obscene. They applied this test from a case called Roth, and they talk about how the test is not perfect. So the Roth test is whether to the average person applying contemporary community standards, the dominant theme of the material taken as a whole appeals to the prurient interest. This is Justice Brennan. He says the test is not perfect, but that any substitute would raise equally difficult problems. And it's sort of an intractable problem, I think, for figuring out what obscenity means as a carve-out from First Amendment protections. The First Amendment is based in the idea that the government should not be making content or viewpoint-based decisions. And something like this, about whether there is the material as a whole, appeals to the prurient interest, and especially the part about having no redeeming social value, is something that's really hard to say, right? This was a long movie, it's close to 2 hours, and to finish that film and say because of that sex scene at the end, it has no redeeming social value because it was intended only to get to that scene. It's a very stark argument to make. You know, we all have seen movies, I assume, that have sex scenes that are much more graphic than this, right? And it's sort of like a daily thing, but if you go back in time and put yourself in this moment, I think it shows the difficulty not only of creating this test, but applying this test to new forms of art, such as magazines, right? The sort of low art where Supreme Court justices and some of the high society weren't comfortable classifying those things as art. There are some early cases where certain jurists argue that motion pictures are entitled to zero First Amendment protection because it's sort of the low art. There are cases holding that, magazines indeed are entitled to First Amendment protections, even though we don't like them as much as we like novels and classic literature. So if you go to the next slide, this is the literary or scientific or artistic value or any form of social importance. So this is Justice Brennan saying that this work cannot be prescribed as obscene unless it's utterly without social importance. And again, that's the very, very difficult line to draw. This case is perhaps most well known for the quote on the next slide. And if you'll go to the next slide, this is Justice Potter Stewart saying what many of you probably know from this case is, let's see. Where should I start? I shall not today attempt further to define the kinds of material I understand to be embraced within that shorthand description, and perhaps I could never succeed in intelligibly doing so. But I know it when I see it, and the motion picture involved in this case is not that. I know it when I see it. One, it implies that at the end of the day, all the Supreme Court justices are going to get together, and I understand that they actually do this. They're going to get together and watch these porno films together and make a decision whether they think it's obscene or not. There are lots of stories from the the United States Supreme Court of various justices watching certain films and making certain of those determinations. This is I know it when I see it is one of those axioms that as a First Amendment lawyer, as a free speech lawyer, really sticks in my craw. Second only to maybe shouting fire in a crowded theater. Neither of them are applicable tests for any First Amendment standard currently, but people talk about them all the time and always reference them. If you have a Facebook account, go to Facebook and go to any one of your friends that are talking about any speech issue, and you'll most likely see the fire in the crowded theater thing as an explanation for why things can be restricted. That is not an intelligible standard, right? Fire. Fire. Nobody went anywhere. That's not criminal. It's not a criminal act. It's still First Amendment protected speech. I know it when I see it as a very similar thing, and this is me editorializing a little bit. I'm getting out of the history to just say that I know it when I see it. You can picture in the hands of a censor is just sort of carte blanche to make something objectionable, make something obscene because you disagree with it, right? So that kind of authority imbued in a judge with really no standards whatsoever to guide future theater owners or filmmakers or anything. This is not a standard that anybody should be using to restrict any kind of speech. But in any event, at the end of Jacob Ellis, the holding of that case was that the film Les Amants was not obscene. So they vacated Jacob Ellis's convictions, and it's sort of a messy point along the obscenity doctrine. And I'm going to try and give you a very quick crash course so that now that you know that I know it when I see it is not the applicable standard, that going forward you know what is the applicable standard. So if you'll go to the next slide, please. This is a very, very rough overview of the evolution of some of this doctrine, starting from before the Jacob Ellis case here in 1964. It took a couple years to reach the court, and in more recent cases. And I'll just give you a very quick rundown of these. So a Chaplinsky case is sort of the first mention of obscene, to my knowledge, in the Supreme Court's history. They say obscene is outside of the scope of the First Amendment. That's sort of what I was talking about before. If something is obscene, it is not protected by the First Amendment, so we don't have to do that analysis under it. And then the Roth was sort of the unworkable early test that is directed to contemporary community standards. After Jacob Ellis, this case Miller versus California in 1973 was about mailing of obscene materials, and it establishes the currently applicable test for now, but I'll tell you why I doubt whether that test still has legs. And then there were a number of cases, and I'll talk about a few of them, but this test, the test that came out of Miller sort of as an expansion of the test in Jacob Ellis, is really difficult to apply in the modern age. So as technology advances, the difficulty in applying that standard to new mediums like the internet and like movies or like any number of things, social media apps, video games even, it's difficult to do. In the sort of 2010s, 2011s, there was a few attempts to expand the definition of exceptions from the First Amendment's protection. U.S. versus Stevens and Brown versus Entertainment Merchants Association both dealt with violent conduct. Stevens was about animal cruelty videos, and Brown was about California's ban on selling violent video games to children. And in both of these cases, the government made the argument that this stuff is so offensive that it should be classified as obscene. And those cases sort of stood for the proposition that violence is not obscenity. In order for something to be obscene, it has to be sexual in content. And then finally, I'll talk about Mattel versus Tom when we get there, but why don't we go forward to the next slide, please. So here in Chaplinsky are the terms where it says there are certain well-defined and narrowly limited classes of speech which have never thought to raise any constitutional problem. First Amendment lawyers still cite this all the time for the idea that you cannot create a new exception to First Amendment's protections, right? So we have defamation that has strict First Amendment standards. We have obscenity. We have speech that's integral to criminal conduct. But just because you don't like something doesn't give you the ability to regulate it. The First Amendment still protects some of that speech. And if you'll go to the next slide, please. This is sort of the development, the first application, and the first holding that obscenity is not within the area of constitutionally protected speech. Next slide, please. This is sort of an interim case that started the development of the Miller test called Memoirs versus Massachusetts. As you'll see, again, we're dealing with content that, by today's standards, would probably be freely available everywhere, right? It's not, nobody would ever even consider something like this obscene, but it starts, you see the doctrine starting to develop, where they talk about the dominant theme appeals to a prurient interest in sex, that it's patently offensive to contemporary community standards, and that it's utterly without redeeming social value. But the court continued to struggle with this test. And if you go to the next slide, this is the currently applicable test, but again, I have concerns about this. So Miller versus California dealt with mailed materials that were written descriptions and some illustrations that were allegedly obscene, and they're almost comical in their banality. Sex Orgies Illustrated is probably the most risque of all of them. One of them was called Marital Intercourse, which is just, I don't know, it's not on my radar of what would be, that would be patently offensive about something like that, right? So the Miller test, this is the test that courts apply these days to see if something is obscene. It depicts sexual conduct, so it's only stuff that's sexual in nature and not stuff that's violent or otherwise offensive. It has to be specifically defined, and that's the big thing in the Miller test. You have to look at a state statute, and there are some federalism issues here where this is governed by state law, but the state has to explicitly define, like in terms of what bodily functions or parts of the body that you see, to make something obscene. Without that specific definition, we're back to I know it when I see it, right? And it gets to be unworkable. So people have to know that what they're doing violates the statute. And finally, it portrays sexual conduct in a patently offensive way, and it does not have any serious literary, artistic, political, or scientific value. And you'll see the test is developing a little bit more where they're getting more specific from redeeming social value into literary, artistic, political, or scientific value. But I would posit that that's still a very, very difficult test to apply. The typical joke in the First Amendment circles are like, this is why you have in like the beginning of modern pornography, like the whole, I'm the plumber and I'm here to check the pipes thing, right? The little bit of plot that they throw in there for you, some would argue is because of this, putting some literary value, right? Attaching a plot to it can take it out of being obscene. And if you go to the next slide, it's just a larger slide showing the Miller test. So next slide, please. This word prurient, it's interesting. I remember being a law student and learning this test, and the test has been somewhat static since 1973. But it's an interesting concept because what they're really saying is sexual stuff that we're offended by. Right, and this was developed in 1973, and you can think of all the advancements in, social acceptability of certain sexual acts that has occurred since then. I mean, if you think of Lawrence versus Texas in 2003, striking down Texas's criminal ban on sodomy, right? That was in 2003, right? So what is offensively sexual to people, and especially when tied to the contemporary community standards that they use, is really still remains a malleable standard that's difficult to apply. So if you'll go to the next slide, it's especially difficult to apply these contemporary community standards as applied to new technology. I also will say here that I have some skepticism that this contemporary community standards test will persist with the modern court if the Supreme Court is currently constituted. Here's a case on obscenity. Contemporary community standards, if you've been reading the Supreme Court's decisions lately, is not anywhere within the stuff they're trying to think about. And it makes some sense that we wouldn't want it to happen in obscenity cases. So if you go to the next slide, this was a case called Sable Communications, and I won't read all of this, but it gets to be a discussion of how to restrict some of these stuff from minors accessing it rather than just a straight ban on it. So this was basically, they call it dial-a-porn, and there were some restrictions, and what this case was really about is about whether the FCC's regulations are enough to restrict this indecent material for minors. It's not a question about whether it's obscene or not. not, but it's a question about whether the FCC can regulate it over the telephone lines. And since there was an alternate way to regulate it available through technological means, then the straight ban was unconstitutional. And if you go to the next slide, the contemporary community standards question is very perplexing because what community is it, right? If we're talking about Leamon in 1958, are we talking about Ohio? Are we talking about Cleveland Heights? Are we talking about Cuyahoga County? Are we talking about film goers in Cleveland Heights or any of those things? Are we talking about the national standard? And if you'll play the audio here, it talks about, this is the counselor and the Supreme Court justice sort of exchanging how to resolve that question.
But if we look at the record, we will find that the only testimony that this picture offended community standards was testimony relating specifically to Cuyahoga County.
Cuyahoga County. And again, this gets to be a difficult question of how to draw what the contemporary community standards really are. And to me, it's sort of a funny thing thinking about, even Bruce's comments about the counterculture and Kara's comments, right? So like if we're defining our community that way, should we be looking at Coventry Village as the applicable community whose standards we're trying to uphold here? But in any event, it's a difficult task for a judicial officer, a judge, or a panel of judges to apply somebody else's contemporary community standards. Next slide, please. So this was, you could see how you could make your thoughts known about what your community standards were, right? Especially when there are billboards on there showing what you're doing, what you're selling there. You can come out and you can protest. But if you go to the next slide, it all becomes a little bit more difficult when it's all on the internet and sort of within the privacy of one's own home. And courts have dealt with this. If you go to the next slide and play that audio, this is a clip from Ashcroft versus ACLU, which is the second time Congress tried to restrict availability of pornography online to minors. And both times it was struck down as unconstitutional. We don't have to play this audio, but basically what Ted Olson, who was then the Solicitor General of the United States, said that before this oral argument, he searched for free porn online. And when he did it, he found something like 16 million hits. And Justice Stevens asked him that if all the free porn that he called up included any obscene material, and it's sort of a laugh line where he says, I didn't get all the way through. I didn't get to visit all of those sites. But it's I think, a good demonstration of how difficult it is to regulate this stuff on the internet, especially. And if you'll go to the next slide, please. This is the court, actually Justice Stevens, in his concurring opinion, giving that opinion, right? In the context of the internet, community standards become a sword rather than a shield. If a prurient appeal is offensive in a Puritan village, it may be a crime to post it on the World Wide Web. I continue to believe that the government may not penalize speakers for making available to the general World Wide Web audience that which the least tolerant communities in America deem unfit for their children's consumption. So this is sort of the idea that if you just tie it, if you tie this standard to contemporary community standards, then specific communities can define for themselves what is obscene and what's not, and that sort of malleability works itself towards censorship. So if we, and especially when the internet is involved, if you think of, again, the most, prudish, conservative idea of what's proper, you could essentially make that a veto power over the remainder of the country. And I think the justices have historically been very sensitive to that concern. The idea that we would let sort of the most sensitive members of our society decide what the rest of us get to see. Next slide, please. This is just more people protesting pornography. And if you go to the next slide, I'm going to fly through some of these. This were the two cases that I talked about where the Communications Decency Act and the Children Online Protection Act were both struck down as unconstitutional. But these were rather than attempts to ban things directly, rather than to criminally charge people making pornography, it was more an attempt to criminally charge people who made pornography, made it available on the internet, and didn't restrict access, didn't do anything to it in order to ensure that children weren't accessing it. And the court struck these down a couple times. So if you'll go to the next slide, in the first case, Reno versus ACLU, striking down the Communications Decency Act, you get to this idea that the interest in encouraging freedom of expression in a democratic society outweighs any theoretical but unproven benefit of censorship. So you've got to show, in order to accomplish some of the censorship that they're trying to do here, you've got to do the sort of tailoring that we expect in a First Amendment case, that you're actually eliminating the concern that you're concerned about. And if you'll go to the next slide, this is in the majority's opinion on the second case, striking down the Children Online Protection Act. But this is basically Justice Stevens lamenting that he wasn't able to uphold the Children Online Protection Act as constitutional. He understands that the protection of children from access to harmful material on the web is compelling, but the court cannot take what it calls the majoritarian will at the expense of stifling the rights embodied in the Constitution. The court is basically saying that it doesn't see a way for Congress to regulate the internet in this way, because it restricts so much information that is not obscene from adults seeing it towards the interests of children. And actually in this part, Justice Stevens alludes to Justice Kennedy's opinion in the flag burning case, and talks about how there are certain cases, and you can go to that next slide. There are certain, because this is not it, I cut it from the slide deck, but basically there are, I'll just read it. Sorry, go back. Indeed, perhaps we do the minors of this country harm if First Amendment protections, which they will age inherit fully, are chipped away in the name of their protection. So basically, these attempts to regulate the internet to protect minors should fall. And actually, go ahead. Can you get to the slide that says Mattal versus Tom? And I'll talk about this because the third prong of this Miller test is, the second prong of the Miller test is that it's patently offensive. But that was developed in 1973. In 2017, this is a case about registering offensive trademarks. So Simon Tom was registering a trademark for his band called The Slants. And it's really a derogatory, a racial term. It's an Asian band, and they're using the slants as their slanted eyes. But he is Asian, and he's sort of reclaiming it. The trademark office denied it because it doesn't allow offensive trademarks, and he appealed it. But in the end, you get up with this Kennedy opinion that says giving offense is a viewpoint, which sort of throws all of this test for obscenity, which is keyed to whether something is patently offensive, in the blender, right? If giving offense is a viewpoint, and the First Amendment prohibits viewpoint discrimination, then how is it one element of this test for obscenity that people are offended by it? There are even First Amendment decisions out there that say if people are offended by it, then maybe it's especially important speech, right? The First Amendment exists for that kind of unpopular or political speech. There's not a need for the First Amendment in speech that everybody agrees with, because there are no attempts to censor it. So I'll just use that to point out that I'm sort of dubious about the future applicability of the Miller test, especially should it get up to the Supreme Court, and especially should it get up to the Supreme Court that includes some of the members that were on the panel here. I guess I'll just close this with the idea that the obscenity and especially the protection of minors are often used to censor things people disagree with, and we've been through, and I haven't lived through them as an adult, but I know that there were certain moral panics over the years, about Parents Music Resource Center, right? Tipper Gore and censoring music, even the Mapplethorpe stuff, the exhibiting of, and I had a slide on here with some BDSM stuff. Here's the PMRC, and if you go to the next slide, this Mapplethorpe exhibition where Dennis Berry, who actually lives in Cleveland Heights. Bruce, do you know Dennis? Okay, so he lives over in Herrick Mews, or at least he used to. And he was the exhibitor of Robert Mapplethorpe's photography, and his studio was raided, and he was charged with obscenity, and he eventually beat that case. And if you'll go to the next slide, I would also argue that we're sort of in another era of this moral panic with these book bans and things, where the idea is that we are going to protect minors from seeing certain things because they're inappropriate, and a lot of times people even say that they're obscene. And I would say that the cases as they've developed have really cautioned us against trying to weigh this kind of literature, this art, in a way that says that if we disagree with it, we should be comfortable with the government censoring it. I tried to rush through. I hope I didn't go too much over, but that'll be it for me. I just want to sort of raise our awareness of this body of law. If you walk away from this presentation with anything, just know that I know it when I see it is not the applicable standard you ever want to talk about, and for that matter, fire in a crowded theater isn't either. I'm glad that you all came out, and I appreciate it. Thanks for hanging with us today.
Presidential assassination, and for those of you who want to partake, we're going to leave here, and an optional falafel over at Tommy's.